Good evening, everyone. Welcome to the Kent County Board of Adjustment meeting for December 16th, 2021. And we are going to call this public hearing to order. When you're ready, would you please call the roll?
Yes, ma'am. Mr. Nichols? Thank you. Ms. Hudson?
Present.
Mr. Saunders?
Here.
Thank you. Mr. Jenkins?
Here.
Mr. Carlson?
Present.
Ms. Denny?
I'm here.
Thank you, ma'am. That's 6 present, 1 absent.
Okay, thank you. Will you introduce the staff, please?
Yes, ma'am. My name is Jamie Fensky, and I'll be the public hearing officer for tonight. I have with me our planning supervisor, Jason Berry, Mark Kennedy from IT, Scott Blair will be sitting to my right, and Fred Townsend, our attorney.
Thank you. At this time, I'm going to ask that everyone rise and pledge allegiance to our flag. Any additions or deletions to the agenda?
No, ma'am.
Okay, so at this point, will you introduce the public hearing, please?
Yes, ma'am. So good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications and the appeal before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed necessary. To make statements when your application is called and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by staff. The board will then receive testimony from all those in favor of the application, followed by testimony of those opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471, or check the Kent County Planning Department website to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on November 29th, 2021 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. At this time, we are going to have a statement by counsel, the counsel that represents this Board of Adjustment, so to help those who are wanting to give testimony this evening, an opportunity to have a better understanding of what is appropriate as testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denny. This statement relates to those of you who are here in support of or opposed to the granting of a variance, an area variance. We'll have a second brief set of instructions that relate to anyone who's interested in commenting on the appeal as a party or as a member of the public. So with respect to area variances, the test for granting those is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The legal standard for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, this board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And also, this consideration is where the board considers whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board is not permitted to consider factors other than the ones I've listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the nature of the zoning district, the characteristics of the area, whether the variances would seriously affect neighboring properties, and whether the applicant's confronted with challenges that rise to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and members of the public, as the board is not authorized to resolve those disputes. Thank you.
Thank you. Thank you, Mr. Townsend. So when you're ready, let's begin.
First, we have application A-21-44 for Toe and Whitehead. If there's someone present, please raise your hand. Thank you. All right. So they are seeking a variance for a fence to go in the front yard. The variance is from the requirement, applicant is requesting a variance from the 25-foot front setback to place a 6-foot fence. The applicant is requesting a 24-foot and 4-inch variance to allow a 6-foot fence to be placed 7 inches from the front property line. The fences are located within a front setback and limited to a 4-foot in height. Here you will see in red the proposed area of the fence that's going in around the yard and in the front setback. This is the front of the property, looking down towards the corner of the property, down the other direction of the road, down the side of the property where the fence is going in the front property, again in the front, and looking back towards the corner of the road, in the area. If you would like to come forward and state your name and address and allow our attorney to swear you in.
My name is Melissa Tao, and my address is 173 Lulu Lane, Dover, Delaware 19901.
Can you pull the mic up just a little bit because we record this?
Is this better?
Thank you.
Sure.
And in addition to that, we're wearing masks, and it makes it a little bit harder to make out what you're saying. So if just try and stay close to that mic.
Okay.
Ma'am, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
So I'll try to keep it short and straight to the point. Our fence, we would just like it to go from the back of the house to the back of our property. With the 25-foot setback, we kind of get stuck with that side yard being a front yard. And if we had to set it back the 25 feet, we would lose a lot of our property. We have 2 large breed dogs, one of which can unfortunately jump a 4-foot fence. So in order to be able to keep everybody safe, including them and our neighbors, we would need to do the 6-foot fence to be able to contain them. We did speak with some of our neighbors. The neighbor directly behind us requested that we pull it back a little bit so that she would be able to see backing out of her driveway. So we did meet with her, had her bring her car to the bottom of the driveway, made sure that the fence was set back enough so that she would be able to back out without a problem. So I think the measurements that we all agreed on was that the fence would come from 16 feet back from the road and an additional 6 to 7 feet back from the sidewalk. I think really the only argument that anyone in opposition made was just that it is a large fence and it will obstruct the vision, mostly just of our backyard. But I do think that if we pulled it back any farther, that we would lose and it would give us a greater difficulty with the loss of our property, but nobody would gain anything. If we set it back on the property line, they don't lose any property. If we bring it in 10 or 25 feet into our yard, they still don't gain anything because that yard is still our property. So that's really the only argument that I can think of. Other than that, I think we've tried to accommodate the neighbor's requests and make sure that there's no safety issues. And now the only safety issue that remains is whether my dogs can hop that fence or whether we can contain them and let them have the yard that we were hoping to have.
Go ahead.
So when we look at the schematic that's up there now, what portion of that schematic would be enclosed in the 6-foot fence?
So that red line should be, the property line, I believe, is the dashed line, and the red line is the fence. So the fence would go within 7 inches of our property line in the back and side of our yard.
So all of that that's marked in red would be 6 foot?
6-foot privacy fence, yes, sir.
Okay, does this parcel also have 2 fronts? What would be considered 2 fronts?
So I think that's what they're saying is the side of the house on Mariana Drive is considered a front. Even though it's the side of our property, it's a front because of the corner lot.
Thank you.
Sure.
So the lot or house that is directly behind you, yes, on your backyard behind Mariana, on Mariana, like as it goes around, where's their driveway?
So you can sort of see the mailbox in the picture. Her driveway's right on that mailbox. There you go. So we had her bring her car to the bottom of that to make sure that where we had the flags for the fence would be far enough in that she would be able to see out her driver's side window without that fence obstructing her view of the road.
One of the things that always comes to my mind in situations such, applications such as yours, I should say, is that, in communities, yours happens to have sidewalks, not all do, but either way, if there really certainly in a neighborhood needs to be more than just appropriate, but safety-wise appropriate, amount of visibility for the kid on a bike or the child on a tricycle on the sidewalk, or, I mean, it's would appear as though it's directed to traffic, but it's not just automobile or vehicle traffic, it's also, walking, just foot traffic, kid traffic. So, I just kind of, and it's difficult, but pulling out of that driveway just to be certain that that 6-foot fence is not going to obstruct the view, not only of the street, but of the sidewalk, in case there's a kid roller skating around or skateboarding or whatever around that corner. And it's hard to ascertain with this aerial view, but at any rate, I just want to mention that.
Sure. So the corner, the fence itself will go over 100 feet back, and that's just from the back corner of our house. So I think even if there was someone turning the corner, it would be a significant enough of a distance, especially with it being 16 feet from the road, that by the time she got down towards the fence, that she'd be able to see around that corner.
Okay.
There's also, on the opposite end of the street, there's an identical corner property with the same 6-foot vinyl privacy fence right up to the property line.
Okay. Anybody else have questions or comments?
Yes, I have a question for the staff. I don't know what your experience level is with this particular development. Would this be a trend to do this, or are there other 6-foot fences in the vicinity?
So as she stated, there is one farther down on another corner down this road. Besides that, I'm sorry, I don't know how many 6-foot fences have been placed in there.
There are several from what we could see. One directly behind our property that's poorly maintained, as I think one of the neighbors was pointing out, but I can assure you that we take great pride in the appearance of our house, and that will not be a problem for us.
Anybody else? Mr. Townsend.
Is it Towel? Is that? Mhm.
Yes, sir.
So the fence is not constructed at the present time, right?
No.
So you've elected it to be a privacy fence.
Yes.
If it was not a privacy fence, and instead some kind of a rail fence or, a vinyl fence, might it present less of a, might it obscure vision less than a privacy fence? And what's the need for a privacy fence?
So just in my experience, I haven't seen any of those that are 6 foot, at least none that are visually appealing. So when we saw that there were other 6 foot vinyl privacy fences in the neighborhood that look nice and are well maintained, we opted for that option because it looks nicer than something that would be chained or metal.
And what types of dogs do you have?
We have 2 Labradors,
Like black Labrador retrievers or?
yellow lab and a chocolate lab.
Mm-hmm. That's all I have.
Okay, anybody else? Thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application? Is there anyone that would like to speak in opposition of this application? One at a time, please come forward and state your name, address, and allow our attorney to swear you in.
Good evening. My name is Jean Betley, and I live at 182 Mariana Drive. I'm the one that has the driveway that you've been talking about.
Ma'am, do you affirm that your testimony tonight will be the truth, the whole truth, and nothing but the truth?
I do.
Please do.
Thank you. As I said, I live at that address. I've been there for since 2006. I walk the development. I'm pretty aware of what goes on in my development. I had received a letter from your agency about the applicants wanting to erect a 6-foot fence. It didn't say anything else about a variance. And I was just concerned about where that fence was going to be on where we share a boundary line. So I went over and introduced myself, and they told me that they would bring it back a little bit so that they would maintain both sides of the fence. That's when I found out about the 25-foot variance that I didn't know about. And I had some thoughts about, maybe I wouldn't be able to see people coming down the road. So I did take my car to the end of the driveway, and I tried to just imagine a fence there, and I could see up to the stop sign. However, like the next day or the day after that, I realized when I pulled out of my garage that I already start to look on both sides to see if there's cars or kids or people walking their dogs, so that I can be cautious about backing down. I don't want to back all the way down there and somebody's right there all of a sudden. And I would not be able to see that with the fence. If I'm starting back where I back out of my driveway, just turn the corner a little bit, I would not be able to see that fence. So I don't want to be put in a position where I might hurt somebody or one of my guests would hurt somebody. So I do have a problem with the 25-foot variance. Some of the questions or standards that were reviewed or recommendations by the board I wanted to address. It says from the applicant, several similar fences have been permitted through the community. But here, there's about 127 homes there in that development. And there are a lot of fences. Most of them are like a wrought iron 4-foot fence. There is on the opposite corner, the applicants live on Lulu. I guess it's like 2 blocks down. On 15 Lulu, there is a corner house that has a privacy fence. that obviously didn't adhere to a 25-foot setback on the side where it's supposed to be called the front, but it's not really the front of their house. And one of my neighbors did some research on that and found that the owners of 15 Lulu did apply for a permit, and they applied during COVID. The planning office said that the permit was issued in error. The error is that they didn't explain in the permit that it was contingent upon them getting variances and other permits that are required by the state and the county. And so that fence went up in error. But afterwards, they owned that error, and they said, well, we can't make the owners take it down. So it's not really setting precedent for anybody else to put up a fence like that because it was done in error. There is one other fence that I know of that's 6 foot, and it's just a property that has a backyard. It's not on a corner lot or anything like that. It's not on a lot where the back fence would be like my side front yard. One of the other statements, I think it was in number 2, the staff describes the character and uses of the vicinity. It states, fences are normal improvement with the development within the character of the area. And that's pretty much true, except that the applicants, the fence that they want to put up is not. It's not consistent with the area. And whether the removal of the restriction, this is in number 3, whether the removal of the restriction on the applicant's property would seriously affect neighboring properties. So the applicant stated it would not seriously affect the neighboring properties, would not impair any line of sight or interfere with the sidewalk. And I take issue with that because, yes, I did say to them I could see when I came to the end of my driveway. But then I learned that I needed to be looking ahead of time. I can't wait till I get to the end of my driveway to do that. And the applicant stated that the HOA, I missed something here, but the applicant stated that the HOA gave them full approval to proceed. Well, it's really approval with contingency that they get the variances, so it's not full approval to proceed. And the last, number 4, whether failure to remove the restriction would cause unnecessary hardship. So the applicants state they positioned the home to maximize the amount of fence available to their dogs, that both dogs could jump over a 4-foot fence, and they had no option but to put a 6-foot fence in to maintain safety for them and for the neighbors and their pets, because one of their dogs doesn't like other animals. They're both friendly to people, but one dog doesn't like other animals, so they didn't want a see-through kind of fence or anything, and it couldn't be 4 feet. So, when I talked with the applicant, I had told her originally that I didn't see any problem with her having a 6-foot fence. I realized that. And I realized that they don't need a maximum amount to protect anyone. They don't need the maximum amount of property. But if they had to go with the 25-foot setback, yes, it would cut off like a quarter of their backyard. So I would agree to them putting the fence 10 feet off of the boundary to parallel to Mariana instead of the 7 inches. If they brought that 10 feet in from their boundary line, I think that is easier. I would be able to see more I'm getting to the middle of my driveway backing out, and I think that would be a safer way to go. So I thank you for your time. I don't know if you had any questions for me.
Yes, Jenkins, I have a question. It's in regards to your comment about the fence and its consistency with the character.
Who am I talking? Who's talking? Because everybody's got a mask on. I'm sorry. Okay, I'm sorry.
So what do you mean? Can you explain what you mean by that when, in your opinion, that fence would not be consistent or out of character with the community? Can you comment on that?
There's no other fences in the community like that. It's a 6-foot fence. It's kind of gaudy to have a 6-foot fence hanging out in the front of my yard and totally, very close to the side, but I mean, there's a little room. And it's not in character with the rest of the community. The rest of the community has some, like I said, wrought iron kind of fences, 4-foot fences. And the one that has a 6-foot that's similar as a corner lot, that permit was issued in error and shouldn't be there. Did I answer your question?
Yes.
Okay.
I've got a question for you. Do you feel that sticking with the 6-foot fence, if it was not the privacy fence, but one like a chain link or whatever it would be that you could see through, would that permit you to, if it was stayed just the way it was, but it was see-through when you're backing out, would that?
I'm pretty sure I could see through if it was like a chain link fence or whatever. I don't know if that's what the owners would want because they have the one dog that is not friendly towards pets. People do come up to fences when they see dogs out. But yes, I could see through that, I'm sure. I wouldn't
But you would,
want it.
and you would be okay with if you came in 10 feet off of the Mariana, you think that would suffice, even if it was the fence they're talking about now?
Yes.
Okay, thank you.
I had
Thank you.
a question. So if they decided to put in trees, these little green giant trees that grow up to 20 feet tall, instead of a 6-foot fence, how would you exit your driveway that way then?
I wouldn't be able to see.
That's what I was just trying to figure out, because they can put a tree, so that's what I wanted to know. Is it coming down the driveway you're having the issue, or is it exiting, like, onto
When
the
I'm
road?
backing out of the driveway, I can't wait till I get to the end of the driveway to see if people are coming, because there's kids on motor scooters and bicycles and people walking their dogs. If I wait till I get to the end of the driveway, then they're there. They're already there. I don't want to take that chance. I want to be able to see when I'm backing out about middle of my driveway, I want to be able to see what's going on behind me on both directions, so I know what's happening and I know what to prepare for. That's pretty much it.
So I have a question.
Yeah.
It's hard for me to tell from that photo where your garage is, but when you come out of your garage, your only option is to back down the driveway.
I can back the other way towards my trees over here. I can back out that way and then drive
see
down
it now.
that way. Now, if I have company over and they're backing in there and I have guests for that's a traffic jam there. Yes, but I could back that way if I needed to. I usually don't, but I could, yes.
Okay. And again, I tend to just think from a safety standpoint, if that were me, I would be doing my best 90% of the time to turn around and come forward out of the driveway, just as a matter of safety. So I just wanted to ask that question.
You could be right. Before anybody built there, that was all farmland. That's all I had was farmland, no houses back there. So
So
it
you could
was
see forever.
changed a lot.
Okay, anybody else?
Thank you.
Thank you.
Thank you.
Is there anyone else that would like to speak in opposition of this application? One at a time, please come forward and state your name and address and allow our attorney to swear you in.
My name is Ginny Bean, and I live at 128 Mariana Drive. I'm the neighbor of
Ma'am.
Jean Bentley.
Do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but?
Yes, I do. Okay. My property is right on the side of Jean Bentley's property. The fence, my biggest complaint with it is that it's unsightly. You know, a 6-foot white plastic fence. That's what it is. There's no, it's all together like this. You can't see through it. You can't see anything. And there it is. And some people that have them, I'm not saying this will happen here, but they don't really keep it up the way it should be. Now, if, for instance, they could put up on part of the time a chain link fence that's 6 feet, with landscaping. Doesn't have to be 10 feet tall, but some landscaping that would hide the fence and keep the property looking nice. It's a very nice development. Everybody keeps their property up pretty much, and I hate to see it look like that. Now, the other fence that people got the fence put up when they didn't get the proper permit, and that doesn't look good either. It's really, and they're the only ones in the whole development that have that kind of fence. So that's my complaint. I think it takes away from the property in the community.
Okay. Does anybody have any questions? So I'm looking at the house behind in the photo, and you are the next house down. Is that your house would be at the bottom corner, or the bottom?
Yes, I think so.
Okay. So, and your driveway, you egress your driveway on Mariana, but
Yes.
just the same.
Yes.
And do you feel as though that's do you feel as that's a visual issue, or you come out?
I
far
come
enough?
out, yeah, I back out of my driveway. And I think that it could be a visual issue. I was trying to look at the stop sign to see if I could see the stop sign coming out of my driveway before I actually. And I mean, I'd say if you were careful and were looking in that direction, you'd probably be okay.
Okay, well, to be honest with you, my question wasn't to be an if this or if that. I just wanted to know if you felt at the moment, if there was a fence there, it would obstruct your view. And it sounds to me like you back out of your driveway as well. So everybody who backs out has to be extraordinarily careful, because
Well, I
there's a
don't always
sidewalk
back
there.
out. I don't always back out because I can, swing around and then go down.
Okay.
Face first, but I just really object to the way it looks.
Okay. All right, thank you.
Yes, I have one kind of general question or observation. If it's the type of privacy fence that I'm thinking of, how would you know what's going on inside? As far as if it's closed in and let's say it's not maintained properly, how would you know with a 6-foot privacy fence that they're not either cutting their grass or whatever would detract from the neighborhood?
It's around the edges on the bottom that you can see on the outside.
Okay, thank you.
Anybody else?
Is there anyone else that would like to speak in opposition? Please come forward and state your name and address and allow our attorney to swear you in.
My name is Joe Tallarico. I live at 17 Connie. I represent the HOA, Moores Meadows.
Sir, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You can raise that mic a little bit.
Yeah.
Thank you.
Just agreeing, the HOA stand is 10 foot off the property line, which would allow visibility going down from one end of the street to the corner. We went over to the property and we decided that the 10 foot. So I concur with the young lady behind as far as that much of a setback. I don't agree with 25 feet. I think the people should have as much property as they can get. But as far as the HOA goes and safety for the neighborhood, we agree with 10 feet off the property line. That's it.
Anybody have any questions?
Are you talking about 10 feet off of Mariana and off of the
Just on Mariana.
Okay.
Just on Mariana.
Yes, I have one brief question. So when you consider the testimony, I believe it was Jean Bentley, her
Yes.
concern about the visibility in the mailbox and backing out, you still stick with that 10 foot off?
Stick with the 10 feet. Yes. That's a sort of a happy medium. They get more than 25. we get our visibility for safety purposes.
Okay, anybody else? Thank you.
Oh, thank you.
Is there anyone else that would like to speak in opposition of this application? Please come forward and state your name and address and allow our attorney to swear you in.
Teresa Murphy, 181 Mary Anna Drive, Dover.
And would you repeat your name, please?
Teresa Murphy.
Ms. Murphy, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed.
I live across from Jean, and I'm also representing my mother, who lives across from the house in question. She lives at 221 Mary Anna Drive. I concur with the 10 feet. I think that's a compromise that would be fair for everybody. We're talking about line of sight for cars and Jean coming from Mary Anna toward Lulu. I'm concerned for line of sight coming from Lulu, which is the road above them, and people turning left or turning left onto Mary Anna. Because right now, most of the development, there's no fences around any of the roads, so you can really look through everybody's yards, and you can see cars or bikes or kids or all the walkers. So this way, somebody coming from the Hopkins is the house we're looking at right now, the yellow house. If you were at Hopkins in your car, and if the fence was right on the property line, you really would have no line of sight. You would have to wait until you were practically right on Mary Anna to see if anybody was coming. So, and we all know kids, they don't slow down. So, and I just wanted to clarify, I'm a current board member. Chain link fences in Moores Meadows would not be allowed. So that's.
I'm sorry. Are you familiar with like a Jareth fence? I said vinyl earlier, but what I meant to say was like a Jareth fence, which is an aluminum fence with rails.
That's what I have. That's what Jean has. That's what most people have.
Mm-hmm.
Yeah, and most of them are 4 feet. We do have a few 6-foot vinyls. They're surrounding pools. There is a 4-foot vinyl that is on the neighbor's property next to me. He's blocking his line of sight from a pond. He didn't like to see the pond, so there is a 4-foot vinyl. When I walk, which I walk a couple times a day, I've really tried to pay attention to the fences, and we do have vinyl, and I believe we may have, I want to say 3, maybe 6-footers right now, and they're all in the back except for the property at 15 Lulu. I was the one that came to the office here yesterday and asked about the permit because I was just questioning why 15 Lulu was not being handled the same as this applicant, and that's when the staff said that due to COVID and people working from home and not all working together, that permit should have required a variance process like this. So that's why their 6-foot vinyl fence is right on the property line.
I have a question for you. So what you're saying in essence is, in your opinion, if the fence that's along Lulu, which is the drive in the front, if it was 10 foot back, like along Mariana, that would probably would work better?
It would work a lot better than being 6 inches off, yes. I don't want them to lose 25% of their backyard. I don't think anybody really thought that you have 2 front yards. I mean, that's kind of I understand. It's a requirement for line of sight, but it's there for safety. But I think going from 25 to 6 inches is, we need to have a meeting of the minds. That's just my opinion.
Anybody else?
Yes, I have a question in regards to if you were approaching that stop sign to make, let's say, a right turn, are we able to determine what position that car might be in? Would that car even be visible if the fence were there, or is that too hard to determine?
Am I driving down this road right here? Okay. If I had somebody coming from Lulu and they were, say, right before the Hopkins house, which is to the right of the yellow house, and if I was next to their, proposed 6-foot fence, If it's right on the property line, then you just kind of lose your timing of what's coming. Whereas right now, it's totally wide open. And this look, other than the intersection at 15 Lulu, this is the look of the rest of the development.
Okay, thank you.
Yep. I had one more question. What is the speed limit in your neighborhood? Is it 25?
25.
Okay, thank you.
Mr. Townsend?
Just, could staff confirm that a 6-foot fence would be permitted on the opposite side? And a 6-foot fence could run, yes. So as I look at that, the opposite side would be the right side. A 6-foot fence would be permitted, at least by county code, on the right-hand side of that lot.
Correct.
And also, a 6-foot fence could run from the right corner towards the left corner until it reached the setback, at which time it would have to be lowered to 4 feet. Otherwise, it's going to violate the setback. A 4-foot fence can be on the property line. A 6-foot fence has to be inside the setback.
Correct.
So in terms of losing yard, that's a...
So all of that yellow area there shows the setback and the area that they would not be permitted to have a 6-foot fence. They would only be permitted to have a 4-foot fence in that area.
Thank you.
The other 2 red lines, if you will, would be allowed to be 6-foot fence.
Anybody else?
Is there anyone else in opposition of this application? Seeing no one, the public hearing for application A-21-44 is now closed. Do we have someone present for application A-21-45 for Jason Munyon? Thank you. Okay. So Mr. Munyon is seeking a variance from the required 150 foot of road frontage to perform a minor subdivision. The property is located on the west side of Briarbush Road, approximately 1,090 feet north of Woodleytown Road, northwest of Magnolia Levy Court District 4th, zoning district AC. The applicant is requesting the variance from the 150-foot road frontage to enable a minor subdivision. The applicant is requesting a 50-foot and a 55.13-foot variance to allow the new lots created by the minor subdivision to have a 100-foot road frontage and 94.87 foot of road frontage. Here you will see that the applicant is seeking to do a minor subdivision to create 3 additional lots from the subject parcel. Here's the front of the parcel, and looking down the road and in the other direction around the curb, towards the side front yard and back towards the front, and the aerial. Sir, if you would like to come forward and state your name and address and allow our attorney to swear you in.
My name is Jason Munyon, address 47 Greenwich Drive, Dover, Delaware.
Mr. Munyon, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
And if you would pull that microphone a little closer, please. Thank you.
Okay. First, I thank the board for their time and hearing, and actually take a moment to thank the planning staff. They've been nothing but courteous and professional through all this, and I appreciate that. Thank you. First and foremost, I'm not a developer, so please excuse any of my ignorance or nervousness through any of this. It's not my cup of tea. I'm a homeowner just trying to build a forever home. I've been working this for a few years, designing a house and looking for land, have not been able to find that, and this opportunity arose where I could take a chance and acquire this property and subdivide it, and in the long run end up with the residual lot to the east in order to build the house that I'm desiring. So that's why I undertook this project. But it was not without its perils. Some of the things, the curvature, the odd shape with relationship to Briar Bush and the existing 1850s farmhouse and barn on the property present some challenges with subdividing this lot. It wasn't just straightforward, cut it into cubes. I do want to point out a small error here. The actual application isn't 194.87. It's actually 100 and 100. It's very difficult to see, but you notice there's a 5.13. That's supposed to be added on to the 94. So I actually submitted it as 100 and 100. It's minor and it's easy to miss, but I wanted to point that out. So I have read the staff's summary, and I do have to respectfully disagree with them. Again, they've been completely professional and helpful through all this, but in reading through it, they proposed a few options on other ways to address this subdivision, one being only dividing off 2 additional parcels. In doing so, that would negate the use of the entire east portion of the property. Again, that's the portion that I'm trying to acquire to build a house on, so that really doesn't work for that issue. Secondly, it notes that if I were to connect to county sewer, the frontage requirement is only 100 feet at that point. That's something I actually am aware of. I looked into that because it would have been my preference. I met with Public Works. There is no viable sewer in the immediate area able to connect, because I'd rather have actual county sewer than a septic system anyway. I think wastewater treatment plant's a better way of dealing with things. Unfortunately, that wasn't readily available. There is a proposal for a private road as well as a means of achieving the frontage for the parcels. Unfortunately, one of the things, and I guess this is probably why I'm here more than anything, that I was trying to do in this whole process is not only divide the property, but also respect the existing house, the existing structures, the existing neighborhood. And like I said, it isn't a house from 1850. It has a very large barn on it. And if you look at the proposed layout for that lot, it takes 100 foot of the front of that farmhouse and has to give it to the residual lot in order to get the frontage there. Again, I end up with the residual, and that gives me more land, but that's not where I think it should be. I think it should stay with that farmhouse. If you look at some of the photos, I've done a lot of work trying to clean that up, and that house has a historic quality, a feel about it that I don't want to impact negatively. Additionally, if you put that road in, you're putting a cul-de-sac and a road right up against the house. You're going to have it's not a busy road, but still headlights and traffic right outside your bedroom window, right outside your living window. So I don't think it's the best way of dealing with that. And that's why I had come back with the proposal. If I had to put a road in, it would probably be parallel to Briar Bush, and it would be 5 feet off of it and redundant. Honestly, with that said, I again, trying to minimize the impacts to this house, my original pass was to try and do a much smaller, even a variance, where I would have the first 2 lots at 175 feet wide, the middle lot with the farm 250 with 150 foot of variance, and leave approximately 25 to 30 feet just for a driveway on the very far right of the property to sneak into the residual, which would be my lot. It was, to me, the cleanest and easiest way to do that. I was told that that was just too small, so that's why I submitted with the 100 foot here to try and compromise. Again, it's not ideal. I don't want to take away from this property. I'm trying to maintain it. But, at the same time, I'm trying to get it accomplished. I've been working on this for years. I will find a way to get it done, but I'm trying to be smart about it, and that's kind of what I'm here for. I have spoken to several of the neighbors. This property was kind of in disarray when I acquired it. Junk cars, squatters, fighting roosters all over the property. People were aware of it, and as I've cleaned it up, people have stopped and talked to me. People that have history of it. Mr. Shrepper, who owns the fir tree farm up the corner, Mr. Metz, who farms the property. Some of the neighbors are here tonight. And speaking with everybody, I've explained what I'm trying to do and how I'm trying to divide this and take into account the existing area. And all the feedback that I've at least gotten personally, everybody seems to be in favor of the idea of trying to do the variance and minimize the impacts to the structure and then in the surrounding area, do it as cleanly as possible, but also supports the idea of having the subdivision. So with that said, I think I will find a way to get it done some way, shape, or form. What I'm asking for the variance, though, is just to not put an undue burden, an undue hardship on that existing structure, not negatively impact the classic appeal of it and the feel of that area. When a simple variance, which there is precedent in your own in documentation from before for variances similar to this, which would be a lot cleaner, simpler, more efficient, and not affect the area as much.
Okay, anyone have any questions?
So, just to be clear, on your lots, the 166-foot frontage and the 165, those are two of the proposed lots?
Yes, sir.
Okay. And they'll share one kind of common drive?
I did that trying to meet the requirements as much as possible.
All right. So when you get over, the lot that you want to build on is on the 11.8 acres, is that correct, on the right-hand side?
The residual, 11.8.
Okay, and because of the curve in that road, that's what's not allowing you to get the 150-foot there?
Correct, yeah. If that road went a little further, it would be a moot point, but unfortunately it doesn't. I even tried to acquire a little bit of the curvature from the neighboring property to make up for it. However, it's family property, and she didn't want to lose any of it.
Okay. So, but you don't really have to divide into 4 lots. Like, the staff did say, even if you were granted the 94 or 100-foot to get to that residual lot, the two on the left were the existing dwelling. Either of those lots could be made into just 2 lots, 2 additional lots. You don't have to have 4 total lots to do what you need to do, correct?
No. Again, my concern, my project has been for that residual lot. So regardless of what happens to the left, the existing farmhouse is still kind of in the middle. So it's really trying to squeeze to the right of that farmhouse and get to the residual lands. Whether the lot 1 and 2 became just a single lot or 2 lots, it probably doesn't really affect what happens to the right of the farmhouse.
I had a question for you. So earlier you said that you couldn't hook up to county sewer?
There's none readily available.
Oh, okay, yeah. It just, in our notes, it said you could, so that's what I was trying to figure out. Okay.
I'm sorry. Could you state your question again, please, Ms. Hudson?
So my question was, if he could hook up to Kent County Sewer, because I believe in our little notes it said that you could, if you hooked up to the county sewer, you would have an additional 4 lots that you could build on.
You wouldn't be able to have an additional 4, but he would only require 100-foot road frontage if he was connected to sewer. Okay. And there is sewer. It is in the sewer district, and it would be able to connect, but it might take.
Yeah, I spoke with Public Works, and I actually have a letter from them saying I wouldn't have to connect to the sewer. The closest one, I think they said, is on Briar Bush at the elementary school, and that's about 3,000 feet away.
So along that line, questioning, would your desire be not to connect to the county sewer because of the cost for 4 lots to connect, or are you looking forward to it coming so you can connect?
If it ran by, I'd prefer to connect to it. Yeah.
Okay.
But I can't put in almost 2/3 of a mile of sewer for 4 lots.
Yeah, it's okay. I get it. Okay. Anybody else? Mr. Crossan, are you okay? Are you okay? All right. I guess that's it. Thank you.
Is there anyone that would like to speak in favor of this application? Thank you. Please state your name and address and allow our attorney to swear you in.
My name is William Alston, live at 1513 Briarbush Road.
Mr. Austin, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. I'm here basically short and sweet. I would be in favor of the variance being granted, being that the proposal that was given to him was basically putting in a cul-de-sac and possibly another road. And I think if that were to happen, it would take away from the aesthetics of the property itself. And then it's a farmhouse. We're out in basically farm territory and things like this. And I don't see the need of putting all that in just to get this accomplished. And I'll be in favor of the variance being granted. Thank you.
Go ahead.
Yes, I have a question. In relationship to the parcels in question, do you have a parcel in that vicinity near
Yes,
her?
I'm the house right next to that. The one right to the left, right off the property. Yes, that's it.
Thank you.
Mm-hmm.
Anybody else? Thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application?
I see no hands raised on WebEx at this time.
Thank you. Is there anyone that would like to speak in opposition of this application? Seeing no one, the public hearing for A-21-45 for Mr. Munyon is now closed.
Our next application this evening is an appeal application, A-21-46. Is there anything else that needs to be stated for the record before we change over to the appeal hearing?
Yeah.
Oh, yes.
I'm going to recuse from this vote.
Okay.
Due to possible conflict.
Thank you.
I believe Mr. Townsend wanted to give some instruction to the board.
Thank you, Ms. Denny. So the board, as you know, because we've been through something like this not too long ago, has a separate set of jurisdictions that relates to the power to interpret the code when someone who claims to be aggrieved by an interpretation of the code files an appeal. So you have the authority under the zoning code at section 399 to hear and decide appeals where it's alleged by the appellant there's an error in an order, requirement, decision, or refusal made by an administrative official or agency on or made in the enforcement of zoning regulations. So I think that's what's before you tonight is an appeal. And in these appeals, you have the authority to affirm the interpretation that was rendered by the planning staff, to overturn that determination, or substitute your judgment entirely for the judgment rendered by the planning staff with respect to interpreting the ordinance that's in question. Are there any questions about that? Okay, so I think the next thing that we're going to do is hear, I think, from the planning staff, just a little bit of an introduction of the planning staff's interpretation of the code provision, and perhaps what the staff would like to comment in response to the applicant's position. We'll then hear from the applicant, and then we'll hear from Mr. Eliason on behalf of the county as well. So I believe Mr. Pardee is here on behalf of the appellant. Is that right? You don't need to get up yet, but do you have any concerns about, or do you have any comments to make before we get started in terms of procedure?
Thank you, Mr. Townsend. For the record, John Pardee with the law firm Behrman, Dallas, Brockstedt, 6 South State Street, Dover, Delaware. Just that since the applicant bears the burden, I would ask for some brief rebuttal after Mr. Eliason speaks. Thank you.
That's fair. Mr. Eliason, anything to add?
No, Mr. Townsend. But for the record, Craig Eliason, County Attorney, Smittinger and Rodriguez, representing the Kent County planning staff.
Thank you. I'm going to add something. When I read the instructions for the area variances, I made some mention of it being incumbent upon anyone speaking either in favor of or opposed to an application to restrict their comments to the 4 criteria that apply to area variances. Those criteria, of course, do not apply in the case of an appeal. But the principle of restricting comments to the question at hand does apply. And there's some reason to think, based on the submissions, that we could expect to hear some argument that doesn't relate, in my opinion, directly to the question at hand. And it's going to be my job to try and keep us focused on what it is we're trying to determine today, and to eliminate matters which are outside of the board's jurisdiction and control. And Mr. Pardee, I know you're not here representing looks like a number of people here who might like to speak. I have no idea whether they want to speak in favor or in opposition, but I believe I recall you having reserved an objection that in appeals matters, it may or may not be appropriate to hear from the public generally about how the board should interpret the code. I think the board would tend to have a liberal interpretation of that and to allow the public to state their reasoning for why the code should be interpreted one way versus the other. But at the same time, we're not going to we're not going to turn this into some kind of a popularity contest, because that's really not relevant whatsoever to what the board's important work is when it interprets the code. Are there any questions for me before we get started?
No, I have no questions, and thank you. All right.
All right, thank you. So, I'll introduce the appeal application and the details on the staff side to start with. So, this is appeal by John R. Kirby. Mr. Kirby is seeking an appeal of an administrative decision, as our attorney mentioned, pursuant to Section 205-399 of the County Code. This is in regard to the requirements for an accessory dwelling unit, specifically an accessory cottage. The applicant's property is located on the west side of Highland Avenue, 225 feet north of West Lebanon Road, east of Camden, residing in the 2nd Levy Court District, and the property is zoned RS1. So to start with a little background here on the request, and possibly even a little bit of information on what an accessory dwelling unit is. It's not something that comes to the board very often in regards to variances, so you may not even be familiar with the term. What an accessory dwelling unit is it allows a second dwelling unit on the property through a county process. There are 2 different types of accessory dwelling units that the county allows. And I'll bring those 2 types here and their definition up here in front of you here. One is an accessory apartment, and one is an accessory cottage. An accessory apartment, as you can see, is a separate complete housekeeping unit that's contained within the single-family dwelling. So that'd be you have your house there on the property, and you have finished off a secondary living space within that house. Typically, those are located in attics, basements, or possibly even additions to the home on the same story. We've seen them all ways. That is not the type of application that the applicant is requesting. But I want to make sure to point out that there are two different types of accessory dwelling units. The second type is accessory cottage. That is the one the applicant has been requesting on his property. These are dwelling units that are built within a detached garage or other outbuilding. You can see that as part of the definition there. On the same lot as the single-family dwelling, so both of these units would imply there is a home already existing. And then this accessory cottage is that living space built and contained in a detached garage or other outbuilding. The reason why we are here this evening for this appeal is that the staff has interpreted and did not accept Mr. Kirby's application for an accessory cottage, because our interpretation of the code and what was submitted, which I'll show you here in a second, is that the accessory cottage was not located in a detached garage or other outbuilding on the property. Our interpretation is that the proposal is for an additional single-family dwelling unit and not an accessory cottage. The applicant, I know as part of their appeal, is interpreting, of course, that their request does meet the definition of accessory cottage, but also has stated that they believe the staff is conflating the definition of accessory apartment and accessory cottage. The staff recognizes that those are two distinct separate uses. One is attached or within the home on the property, and the other is within a detached garage or other outbuilding. So our feeling is that we have not conflated those definitions and do agree that those are separate uses that are allowed in the county. The applicant did come into the building with two separate proposals, which we did not accept the application for both proposals. We just want to show you all those before we move forward. This is what the first plot plan that was submitted by the applicant. The ADU is proposed here behind the home in the rear yard. This is the sketch of what they provided to us as what they requested to be built. And finally, here's some floor plans and elevations of that structure. Again, we did not accept that, felt it did not meet the definition of accessory cottage. Secondly, they came back with another request, a modified proposal, which you'll see here. The garage shape here in the rear yard is a little bit different. You can see it noted there. Here was the requested elevation for that. And finally, here was the floor plan submitted for that. Again, the staff did not accept this application, felt that it did not meet the definition, that it was essentially a second single-family dwelling. And finally, we wanted to show you an example of something that has been approved by the county as an accessory cottage application. This is an example of an elevation of one that the staff interpreted to meet the definition of accessory cottage, where there is living space built within this detached structure here. So that's the staff want to provide an example of what we interpret the code to be met for this type of use. So that's my introduction. Before we move on, maybe if the board members had any questions for the staff, feel free to ask me, Mr. Townsend as well.
Now, Mr. Berry, where is the prohibition found against having a second single-family dwelling on a lot?
That's a very good question. The zoning code allows in a zoning district for one principal use per property. A principal use within this RS1 zoning district is a single-family dwelling, and that doesn't allow for two principal uses. So two single families or a single family and some other principal use. Of course, there are a number of uses in the zoning district. So that's how we would interpret that part.
Anybody else have any questions of Mr. Berry? Certainly, if something occurs, we can, as we always do, refer to the planners. But this would be a good time to ask if you feel any confusion or. All right. I'm hearing none. Let's go.
So I believe then Mr. Townsend said the procedure would be for the applicant's attorney to speak next. Yep. So thank you, Mr. Pardee, when you're ready.
evening, Madam Chair, members of the board and staff and council. John Pardee, law firm Behrman Dallas Brockstedt, 6 South State Street, Dover, Delaware. Counsel for the applicant appellant, John Kirby. Just for the record, I've asked staff to hand out a copy of our PowerPoint, and we also have the PowerPoint on the screen for you. You will notice that there are some handwritten notes in the copy that I handed out because there's been some changes. This was all put together fairly recently, so my apologies for the amendments and notes, but I'll explain those when we get to that point. What is actually being proposed now is shown in the photograph, which is the next to the last page in our packet. And we'll get to that in the PowerPoint, but I want to describe it just very briefly for you at the outset. And of course, it's our position that that does satisfy the definition of an accessory cottage, and I'll explain why, but I wanted to give you the dimensions. What's being proposed is an outbuilding of 1,000 square feet. Within that 1,000 square feet, 600 square feet would be dedicated to the accessory cottage, and 400 square feet would be dedicated to a garage. The principal residence on the property is 2,024 square feet. And this becomes important in the analysis of the language in the code, which I'll speak to. But I wanted to make sure you understood at the outset that what's being proposed is a 1,000 square foot outbuilding with a 600 square foot accessory cottage and a 400 square foot garage. So with that,
Mr. Pardee?
Yes.
Has this already been proposed to the county, or is this something that was developed?
No, it is what was proposed in the second application that was presented but not accepted, which is bizarre to me, but for whatever reason, the planning staff refused to accept any of the applications. But the second application is the photograph that's in our packet, and it's what was shown on the screen just moments ago. You saw that there was a portion of it, which was the garage, and that's 400 square feet. The balance of the outbuilding is 600 square feet, and so it's 600 square feet of accessory cottage, 400 square feet of garage. So this is, in fact, the exact same thing as the second application that was presented but not accepted, and I just wanted to make a record of what the dimensions were. Okay, so with that just brief thumbnail sketch, I'd like to, at this point, ask Mr. Kirby to come forward and explain to you briefly why he has submitted this application. Thank you.
Now, here is where we're going to try and pay close attention to what's relevant to the board's consideration tonight and what isn't. So I'll be asking for your cooperation, Mr. Pardee, as we hear this testimony.
If I may, Mr. Kirby also has a written copy of his comments, which he can hand in, and I'd ask you to give him the opportunity to do that with whatever instructions you deem appropriate.
Mr. Kirby, could you give us your address for the record?
My name is John Kirby. I live at 2025 Highland Avenue in Dover, 19901.
Mr. Kirby, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
Madam Chair, members of the committee, thank you very much for your service. Thank you for allowing me to make my case. With the restrictions that you've mentioned, a lot of my reasons are personal. How relevant are they to the code? You may stop me. In my application, I gave a lot of those reasons. You've probably read them. I'm 76 years old, soon to be 77. I don't want to die in a nursing home. I think a lot of us have that same idea. I've been working on this project for a year. And when I read your code, and it said I could make an accessory cottage.
If you need to take a moment,
I'm fine.
Please
I'm fine,
feel free.
Madam
Okay.
Chair, but it was an answer to my prayer. Now, when I went to the planning department, they were very nice. They wouldn't accept my check, and they wouldn't accept my application. But they said, well, Mr. Kirby, if you just attach this to your house, you wouldn't have any problem. Well, I have a one-story dwelling. If I try to attach it to my house, it cuts off the light. There's no way. I've tried for a year to figure out how to attach it to my house. I can't. And what's more, the code allows for an accessory cottage. Within 3 blocks of my house, there are at least 3 garage apartments. I can't make a garage apartment because according to the code, it has to be the same as the house design. My house is 1 story, so I can't make something 2 stories. That would be a violation of the code. So I thought that an accessory cottage was legal. I believe that the accessory cottage is itself another outbuilding. That's what it is. It's another outbuilding. It's contained within another outbuilding. However, in trying to comply with the administrivia, I said, well, I'll make it a revised application. I'll put the cottage in a garage. Now what's the problem? I was told it has to be in a garage. So I don't understand that. I think what I'm applying for is legal. And I think when I went to the planning department the second time to say I thought they were in error, very nice fellow, Chris, said, Mr. Kirby, you don't understand. I don't want to quote him directly, but in essence, the Board of Adjustment panicked. They're afraid if they let you do this, everybody in Kent County is going to want a little house out back. Well, that's simply not true. Not many people have the means to spend $250 to $300 a square foot for a little cottage. This can't be an investment. It will not pay back before I die. Before I need it for a caregiver, the code allows it to be rented to help recover the cost. But actually, I was quite impressed at how restrictive our code is. The cottage can't be too small. It can't be too big. It cannot dominate the property. There can only be 1 ADU on the property. It must fit into the design of the main house. That's why I can't make a garage apartment. There must be parking for 2 cars off street, and the owner of the main house must live on the premises. So some local landlord can't put an ADU and rent everything out. You got to live there. I have a wonderful home. You know, and I know, I wouldn't make something that I would be ashamed of. It's not a profit-making venture, and it's consistent with the code. And it does help to address our affordable housing shortage today, which we all know exists. Now, maybe what I have to say is not all about the code, but it's about a need in Kent County. It's not going to create everybody wanting to put a little house out back, because it's not a good investment. But we should not discriminate against that class of people who would want to do this. It's not fair. Thank you. Yep.
Anybody have any questions for Mr. Kirby?
I had a question. You speak of having to build a cottage for an aide. Is there a
Yes.
reason why you couldn't use at-home service like visiting angels or someone that would come into the house?
Yes. I'm not a native of Delaware. I've only been here 10 years. But growing up in West Virginia, my family was in the funeral business for 50 years. And we never wanted anybody in the family to die in a nursing home. So we always had somebody on the property. And yes, you can bring somebody in. Yes, that's a possibility. But the code allows you to do this. This is a much better alternative. That's why I've asked to do it.
Anybody else? Go ahead.
I need to know, I've seen a number of pictures. Does this structure, does it exist now or it's only proposed?
No, sir, it's proposed.
In your opinion, if you went forward with this, how visible would that particular structure be from the distance of your primary residence in appearance?
It's at the back of my driveway. It's almost invisible from the street. It's visible to my next door neighbor, but in no way blocks their view. Sorry.
Smith or Jane Smith.
It fits in with the design of the property. It's unobtrusive. I could build this, I'm sorry to go off the point here, but I could build this as stick built. But what I'm trying to do is build this to the highest environmental standards using something called SIPs, structural insulated panels. I went to visit the factory in Kentucky.
Mr. Kirby.
I'm sorry.
We're getting off, yeah.
Could I
I'm
stop?
sorry. I'll stop this final sentence. This construction method is a good example of what we should be doing.
Okay, but Mr. Kirby, this is not about construction methods.
I understand. I'm sorry.
And it's also not about whether the home is, or the proposed structure is potentially or significantly harmful or visible to neighbors and whatnot either. And what's difficult for...
I was asked the question what was visible to neighbors.
What's difficult, right, but I want the board to know that while that question was asked, that's a question that is typical of a variance application, and it is irrelevant. The answer to that question is not relevant to the question of whether the structure you're proposing to build is legal, given the definition of accessory cottage, which is what we're trying to get to, okay? So it's understandable that this board would go to questions like that, and many of the comments we've heard so far relate to why the applicant would like us to come to the conclusion that he has an exceptional practical difficulty and that this serves his need to address the exceptional practical difficulty, but that is not the test that's before this board tonight. This board is substituting its judgment for the planning office, who interpreted the code in such a way as to deny this application. So that's what we're here to get to the bottom of, is whether the planning office interpretation should be affirmed or should be reversed, or some alternative should be reached. So I don't know if we have anything more from Mr. Kirby to hear at this point.
Does anybody have a question?
I have a question. I have a question.
Oh, okay, Jamie. I'm sorry, Mr. Saunders.
Okay. Hey, as your definition, you were saying that when you went in there, they told you that the accessory cottage would have to be attached to or containment within a main dwelling. Who told you that?
Mr. Saunders? Yeah. So it probably doesn't matter who. Yes. It probably doesn't matter who. So if you have a question for planning staff about that, it would be appropriate for you to ask. So do you want to direct a question to the planning staff, please?
Well, the question was based on this paperwork. We said there was understanding of the department interprets the definition of the accessory cottage, and then that's what they said. But that's not the definition of the accessory cottage.
I think what the planning staff was saying is you could build an addition to your house. You could build an addition to your house, and you wouldn't put the planning staff in the position of applying the definition of accessory cottage because it would be an addition to the home. Is that right?
And in addition to the home with a living space in it is an accessory apartment, which is the same process. It has a few different rules, but an accessory apartment is one which is connected to the home as an addition.
And would then be probably allowed if it fit within whatever the setbacks
and the size requirements and other specific details of an accessory apartment, yes.
The issue here is he's requesting is not in keeping with the definition of an accessory cottage. It would be if he chose to put it in his garage, to use your garage. There are other avenues, and I'm sure your attorney has spoken to you about that, so I'm not going to go deep into that.
So Mr. Pardee is going to, I anticipate he's going to argue that point, and I think we've heard from Mr. Kirby, and now Mr. Pardee, you intend to you have additional argument to make, Mr. You do not.
No, Mr. Kirby's done.
Okay, and Mr. Thank you, Mr. Kirby. I don't know if I was misspeaking. I meant to ask Mr. Pardee, do you have more to offer? And I think that you do.
I certainly do.
Right.
So, thank you. I think Mr. Townsend has given you, as he always does, proper instruction about the focus of the hearing tonight. So you noticed at the outset that there are a lot of people here who may want to say something, and I'm going to try to cut that off right here and now. Because this is not about, whether people like the way it's going to look or they don't like the way it's going to look. It's not a popularity contest. But there are a number of people here in the audience who are in support of the application because they believe that what Mr. Kirby is proposing satisfies the definition of an accessory code, and in particular satisfies the requirements of Section 205-397.6C of the code. And I'll get into that code section, but just so we can dispense with a lot of irrelevant testimony, I'm just going to ask those folks who are here that agree with Mr. Kirby's position to stand and be recognized and not come forward. Okay, thank you very much. You may sit. So, a couple other preliminary points I'd like to make. I understand that Mr. Crossan is recusing himself from these proceedings because he lives in the neighborhood. In fact, for the record, he and Mr. Kirby have talked about the application. And I would ask respectfully that if there's any record of any communications between Mr. Crossan and the staff about this application, that those communications be preserved for the record. A little explanation about kind of the PowerPoint you're going to see. When Mr. Kirby first came...
Mr. Pardee?
Yes, sir.
I think that's probably a fair request on your part, but I don't think Mr. Crossan is obligated to explain the basis for his recusal. He's recused himself, and why was... it's not on the record, and I don't think this board should take into consideration why he's recused himself.
That's fair. I just want to preserve for the record that it's my understanding that there were some communications between Mr. Crossan and the staff about the application before tonight.
So I'm going to interrupt because I did receive a note from Mr. Crossan as the chair telling me that he intended to recuse and why. And this is, of course, part of the record. I can, with your permission, I can read it, or we can just know that he did recuse himself. That's what.
I suggest we preserve it for the record, and we'll talk to Mr. I don't really know what the message is, and I don't know that he wants the message read. So I would suggest that we not read it.
And I would agree, Madam Chair, respectfully. It's not my intent to make an issue of that tonight. I just ask that it be preserved for the record.
Okay, thank you.
So just a quick explanation about the presentation you're going to see. When Mr. Kirby first came to see my associate and myself about this application, it was our understanding that the county's position was that the accessory dwelling unit had to be attached to the principal residence, and that essentially the county was conflating the term accessory apartment with the term accessory cottage. And of course, as we'll see, they're completely different concepts. So that's why our PowerPoint was originally set up to talk about the difference between the two. It's now my understanding that the county's position is, and I'm sure Mr. Eliason will speak to this, but it's my understanding that the county's position is that you can't have two dwelling units on the same lot. That's just wrong, okay? You can't have two principal residences on the same lot. That is correct.
Well, I believe that's what Mr. Berry said. You can't have two principal uses on the same lot.
Right, and that's not what we're proposing here. What you can have is a principal use, a principal dwelling, and an accessory cottage. That is, in fact, the very nature of an accessory cottage. If I can figure out how to make this work. There we go. Oops. Is it easier if I just ask you to change the forward? There we go. Bingo. Okay. Technology is a wonderful thing when it works. Thank you. So, and you saw some of this in the staff's presentation, the definitions, and it's very clear that an accessory apartment is a separate unit contained within the structure of a single-family dwelling. An accessory cottage is a separate and subordinate dwelling unit, so you can have two dwelling units, that is located on the same lot as a single-family dwelling but is contained in a detached garage, and here's the important word, or other outbuilding. So it doesn't have to be a garage. It can be any other outbuilding. This property is located in the RS1 zoning district. And obviously, Section 20579 says that accessory cottages are permitted in that district. And then Section 79 talks about the purpose of the district. And therefore, Mr. Kirby's proposed accessory cottage is a permitted use which is consistent with the purposes of the district. Now, this is the part of the presentation that I mentioned earlier. We thought the county's position was that it had to be attached. Obviously, it doesn't. And as we point out, the code clearly contemplates two different types of accessory dwelling units, apartment and cottage. Apartment connected, cottage not connected. This is the really important part. It has to do with whether or not the accessory cottage is subordinate to the principal structure on the lot, the principal structure being the single-family house. Now, I will submit to you, as a matter of just pure common sense, that if you have a code section, like you do, that defines the parameters of an accessory cottage in a way that makes it clear that it's subordinate to the primary residence, then it's subordinate, okay? And that is exactly what Mr. Kirby is proposing here. The code requires it to be greater than 220 square feet. And this is the part of the PowerPoint that I marked up in the copies that you have in front of you. The language is found in Section 205-397.6C1. I'll read it to you briefly. It says, an accessory cottage shall contain at least 220 square feet of floor area. The floor area of an accessory cottage shall not exceed 40% of the floor area of the single-family dwelling to which it is accessory, or 1,200 square feet, whichever is greater. Okay? So it can be as big as 1,200 square feet. It just can't be more than 40% greater than the size of the primary residence. And you might remember at the very beginning of this presentation, I told you that the numbers are the outbuilding is 1,000 square feet. So it's under the 12,000, but it's even better than that because within the outbuilding, the accessory cottage is only 600 square feet and the garage is 400 square feet. So the ratio is really 600 to 2,024, clearly under the 40% and clearly under the 12,000 square foot limitation. By meeting that definition, what is being proposed is per se subordinate to the single-family principal dwelling, because that's how your code is set up to define it. If we were standing here asking you for an accessory cottage of 1,500 square feet, then obviously it would not be subordinate because your criteria in your code would tell you it's too big, okay? The other code provisions are spelled out in the same section. The accessory cottage cannot dominate the area, extent, or purpose of the principal use or structure, and that's clearly the case here. It's not dominating the area of the lot or the extent or purpose of the primary residence. It's a cottage, a small cottage for limited occupancy. It's not a full house. The materials and proportions have to approximate the single-family dwelling, and the same with the architectural style. That is, in fact, what is proposed here, and you have to comply with all setback requirements. That's exactly what's proposed here. Again, 1,000 square foot outbuilding, 400 square feet of garage, 600 square feet of accessory cottage living space. Satisfies all of the requirements of the code. In conclusion, I will tell you that this was set up obviously thinking the argument was different. So ignore that you see on the screen. The conclusion is this accessory cottage that's proposed is in fact subordinate to the single family dwelling, which is the principal use on the property. And your code allows that. It allows 2 dwelling units. It allows an apartment, an accessory apartment, or an accessory cottage. One's detached, one's not. The one that's being proposed here is detached, and it is subordinate because it satisfies all the criteria for subordinacy under your code. If you conclude otherwise, you are basically writing accessory cottage out of your code, and the case law that I've cited supports that conclusion. You can't have a conclusion or interpretation that renders portions of your code superfluous or meaningless. So that concludes. Oh, one other thing I wanted to say, and I think Mr. Townsend touched on this already, but just in case it's not clear, if you have opponents come forward to testify in opposition, and they testify, we don't like it because it doesn't fit in the neighborhood, we don't like the way it looks, and so forth, they don't have standing here. This is an administrative appeal of a code interpretation, and their testimony would be irrelevant to that issue. So we would respectfully request that you ignore it. With that, I'm happy to answer any questions you may have.
Anybody have any questions of Mr. Pardee?
And remember, Mr. Pardee has an opportunity to rebut following Mr. Eliason, so you'll get another crack at Mr. Pardee if you choose to wait.
Thank you.
Okay. Actually, this is Mr. Go ahead, Mr. Elias. We have someone raising their hand in the back of the room. This is Mr. Eliason's time to speak. So if you were raising your hand because you wanted to speak, madam, no, okay. All right. Typically, I don't answer questions, I'm sorry, in the middle of this. It's just the format that this board uses. Mr. Eliason, go ahead, I'm sorry.
Thank you. Again, Craig Eliason, Smittenger and Rodriguez, County Attorney for the Kent County Planning Department. Before I get into argument, I did want to clarify just one or two things with the help of Mr. Berry. In response to what Mr. Pardee stated, my position is that the county's position was perfectly articulated by Mr. Berry at the beginning. Perhaps there was a misunderstanding back on November 1 when this appeal was taken. I don't know. But the position of the county was as stated by Mr. Berry. Now, could we call up the county's PowerPoint, the next to the last page? Yeah, whoops, had the definitions there.
Definitions?
Yeah. There it is right there.
There it is. Yep.
I wish that was larger, but I'm gonna read this into the record because it's important, and then I'm gonna follow up in another context. Mr. Berry, these definitions have been in place since 2009?
2009, correct.
That's when the levy court kind of passed legislation to clarify this area. True?
Yep. Yes.
There were some amendments, there were some new things, and it's the ordinance that we've been working with since 2009?
That's correct.
All right. And you agree with me that the accessory apartment has to be contained within something, and the accessory cottage has to be contained in something, right?
Yes.
All right. Mr. Pardee had mentioned 205-397-6C. Do we have that available? I saw...
I can bring it up, it'll just take me a minute.
I can tell you that at some point earlier on, there was a document created that had a picture of Mr. Kirby's lovely home, and below that, a rendering, if you will, of what the cottage might look like. If we can't find it quickly, I can...
Oh, I'll get there, don't worry. 397. Here we go. 397.6. Which section under 397.6?
6C.
C. Here we go.
Oh my!
Right there.
I'm glad I have it here. I'd probably go blind looking at that. Wow, that's great.
Oh, wait. I moved too far. That's probably as big as I'm going to get it on the screen in front of us.
Yeah, it's
here.
the paren 2. Yes. All right. I want to talk about C2.
C2. Okay.
I'm not a planner, but shall we assume that this dispute has not really gotten to this point yet, or has it?
That's correct.
It has not?
It has not got to the point of talking about materials or roof form or window spacing, right?
But this is helpful in terms of levy court's intent, I would say. Could you just read C2 into the record?
Yes. For an accessory cottage which will be located within a new structure, the exterior materials, roof form, and window spacing and proportions of the accessory cottage shall approximate those of the existing or proposed single-family dwelling.
Do you agree that one of the operative words here is within?
Yes.
Something we saw earlier in the 205 definitions, in and within, right?
Correct.
And this is consistent with that, is it not?
Yes.
All right. Thank you, Mr. Berry. Can we get to Mr. Pardee's slide number 3? Yes. He quotes 20579 in part. The RS1 zoning district is to offer the possibility of a variety of housing types and lifestyles to be harmonious with low-density residential and low-intensity compatible agricultural uses. You see that there? In the code, however, there isn't a period there. It goes on and it states, while protecting the single-family character of residential neighborhoods. So I ask you rhetorically, is this proposed accessory cottage consistent with the purposes of RS1 zoning? Absolutely not. And I'll get to that in more detail momentarily. Could we get to one more bit from Mr. Pardee's PowerPoint? This is terrible. The third from the last page. So conclusion and come back to. Yes. And this could be the most important element that you're going to have to unpack tonight right here. You see all of this? All of these standards, the 40% of the area, no more than 220 square feet, all of that. You don't even get to this until the proposed dwelling is in something or inside of something. This is step two. This is step two, and it's being offered up as step one, which it isn't. On behalf of the planning department, I frame the issue this way, and I just mentioned it. What is so confusing? What is so controversial about in and within? That's the question. An accessory cottage has to be contained in a garage or an outbuilding. There's another provision in the code that you need to approximate the single-family dwelling as well. The definition of a single-family dwelling is something on a lot that doesn't contain any other dwelling unit or not a principal one, which I'll get to. The point is, these regulations do not allow two freestanding dwellings because, with all due respect to the interruption, it does not, and I'll tell you why. In terms of, if you permit this analysis of the code, you'll have the planning department constantly making judgments about what's subordinate and what isn't. Is that really what you want? For the planning department to have to make subjective judgments like that? Here's how you determine what's subordinate and what's not. Again, is it inside something? Is it within something? Then you know that it's a subordinate use vis-a-vis the primary dwelling, right? I'm one of these guys. I always think there's a historical antecedent to everything. I'm a history buff. I don't know if anybody's ever been to Hyde Park, FDR's homestead. It's absolutely awesome. And of course, about 100 years ago, Eleanor Roosevelt, because she could, I suppose, she built Valkill, which is an accessory cottage, right? It has 25 rooms. So the point is, with all due respect to Mrs. Roosevelt, her application to build Valkill under our code as it exists right now, it would be denied for the same reason that this one should be denied. Now, the applicant's request doesn't meet the definition of an accessory cottage because it's not contained in or within a garage or an outbuilding. And if you take, I really appreciated Mr. Kirby's candor when he said that Let me find this. He essentially said that what he proposes to construct, and Mr. Pardee referenced it also, what they propose to construct is it's the outbuilding itself. So if you take that to its logical conclusion, every single freestanding dwelling you build qualifies as its own definition. So everything you build, it's an outbuilding. It's within itself. You know, I don't dispute for a second that maybe our approach here from 2009 could be cleaned up a little bit, right? Maybe all of this should be revisited. But that's a conversation for Tuesday night, not Thursday night. That belongs before the levy court. And then the argument would be, as Mr. Kirby said, these provisions are really very restricted. Maybe they could be a little more user-friendly. I don't dispute that for a second. That's a legitimate point, but not for tonight, because what you're being asked to do tonight is to call into question a spot-on interpretation of the zoning ordinance as it exists right now. And let me just wrap up by saying, yeah, I did say that before, but I'm going to say it again because it's important. You don't want the staff to have to make subjective interpretations. Is this subordinate or not? FDR would say Valkill was subordinate. I don't think Eleanor Roosevelt would say it was subordinate to anything. It was an absolute palace that she built later adjacent to the main dwelling. And I think that's important to take into consideration. And again, the way you know it's subordinate is because it's in something. It's within something. It isn't a freestanding thing that you say, oh, it's within itself. The outbuilding is what we want to build. That's not what's intended here at all. So in short, what's being proposed does not meet the definition of an accessory cottage. With all due respect, it just does not. And it's my view that the board should affirm, I guess you'd say, everything that the staff has done here. And the conversation may wind up on a Tuesday night sometime, and that would be absolutely fine, but not tonight. Thank you.
Thank you. Does anybody have any questions of Mr. Eliason? Looks like you're, it's okay, nobody does.
Well, I'm available if someone thinks of something. Thank you.
Okay.
Thank you, Madam Chair. I'll try to be brief, only 4 quick points. So the language that I cited as Section 205-79 is actually from the purpose provisions in Section 205-76, and I'm looking at the county's website, and I've quoted it verbatim there. It's Section 205-76B. So I don't know where Mr. Eliason somehow managed to come up with language that suggests that an accessory cottage is not consistent with the purposes of the RS1 district when it's a specifically named permitted use in that district. That's the most nonsensical argument I think I've ever heard in this room. A use that is specifically permitted in this district is not consistent with the purposes of the district? That doesn't make any sense to me at all, I'm sorry. Number 2, this question about whether the accessory cottage is in or within, those words mean the same thing. It's in and out building. And the record before you is what's proposed is 600 square feet of accessory cottage within or in, take your pick, either one works, an outbuilding that also has a 400 square foot garage in it. So to suggest that it doesn't meet the definition is mind-blowing to me. I mean, is it supposed to be outside the building? It's definitely inside the outbuilding. Whether you call that within or in, it's the same thing. It's 600 of the 1,000 square feet. So it certainly meets the definition of an accessory cottage. Number 3, this, I guess, policy argument about you don't want the staff to be put in a position of having to make subjective judgments. That's bunk. You've got objective criteria in section 397.6C that tell you it's got to be greater than 200 square feet, it can't be more than 1,200 square feet, and it can't be more than 40% of the principal residence or the 1,200 square feet, whatever is greater. And of course, it has to match the materials. It has to be subordinate. I'm telling you that if your code gives you a subordinacy test, as it does, that's how you know that it's subordinate. Again, if we were here asking for a 1,400 square foot or 1,600 square foot accessory cottage, then your code says, well, that can't be subordinate because it's too big. Last point, and I promise I'll shut up and sit down, and that is the code says what it says. An accessory cottage is detached, and if it satisfies the criteria in 397.6C, it's permitted. If you don't like that result, change the code. And that is a conversation for Tuesday night. Mr. Eliason is correct. But the law, as it stands tonight before you, is that this cottage is permitted under your code. Thank you very much for your time. I'd be happy to answer any questions.
Now, Mr. Pardee, you're not suggesting, and I'm sure you aren't, but just for my board's edification, you're not suggesting that this board can change the code?
Absolutely not.
Right.
Fair question. Thank you.
Yeah, and just as a reminder that this isn't like a variance. You know, we're not changing the rules or making exceptions to the rules. And we do have some relatively new members, and I just want to be sure everybody understands that.
Yes.
This isn't the same procedure as a variance. So I have a question. You know, to me, when I see the photo of this proposed cottage, I don't think the cottage is like if you're considering the garage to be an outbuilding, I don't see where it's in the outbuilding. It just looks to me like he's creating an entirely new outbuilding. And the other thing I don't understand is where, and it just may be the angle of the photo, but I drove over and looked at the property without going on the property. But I guess what I'm also not understanding is where's the ingress egress to the garage? Or is that just a storage shed? Or, an outbuilding, that storage shed?
No, a car could come up Mr. Kirby's driveway and pull right into that garage.
Okay. I mean, it's just the angle that I can't see that. And,
Right.
As you stand in front of the property and you look or go sideways and look down, it doesn't, I couldn't see that.
Yeah, so this is proposed towards the rear right corner of the lot. And you would come in the driveway and then bear around to the right to get into the garage. But it's directly at the end of Mr. Kirby's driveway. So you would, in fact, he's not going to build a garage and not use it for cars, for crying out loud. So it's a garage and, well, let me restate that because I think this is important to capture it this way. It's an outbuilding. Within the outbuilding are two things, a garage and an accessory cottage, and that's what your code permits.
So essentially, he's building a new outbuilding in order to have the cottage outbuilding as one piece.
Yeah, and he's permitted to do that under your code.
Okay. Anybody else have any questions? Mr. Saunders? Oh, I'm sorry.
Hi, Mr. Pardee. I'm new to the board, so bear with me. Is it your contention that a yet-to-be-constructed building qualifies as an other outbuilding under the accessory cottage ordinance? Is that correct? a yet-to-be-constructed building?
I'm sorry, I didn't understand the question entirely.
My question is, in this accessory cottage definition, it says on your slide, a separate and subordinate dwelling unit that is located on the same lot as a single-family dwelling but is contained in a detached garage or other outbuilding. My question is the yet-to-be-constructed building what you define as an other outbuilding?
Excellent question. Yes, that's exactly what it is.
Thank you.
Thank you. Mm-hmm.
Anybody else? Mr. Townsend.
Can you help me make sense of the word "but" in that sentence? Why is there a "but" at all in the definition? Why not?
I think a fair question. I think to distinguish it from an accessory apartment, because that definition comes right before accessory cottage, and it's my understanding, and maybe Mr. Berry can clear this up, that the definitions of accessory apartment and accessory cottage were created relatively recently. It might have been 2009, but prior to that, the county just had a definition of accessory dwelling unit, and it didn't make a distinction between the two, apartment and cottage. And so I would submit to you that the word "but" is in there because it's a reference back to, hey, we got this other thing called an apartment, and we defined that a sentence before to be a separate, complete housekeeping unit that is contained within the structure of a single-family dwelling. And now we're going to tell you that an accessory cottage is a separate and subordinate dwelling unit that is located on the same lot. I mean, obviously, an apartment is going to be on the same lot because it's inside the building already. So they had to say on the same lot as a single-family dwelling, but it's not in or attached. It's contained in a detached garage or other outbuilding. So I think that's the significance of the word "but," to help distinguish cottage from apartment.
Anyone else? Thank you, Mr.
Thank you, Madam Chair and members, for your time.
I have one question for Mr. Townsend. Can I respond to your inquiry about the definition of accessory cottage?
I'll allow it.
Right.
I agree with one part of what Mr. Pardee said. It's to distinguish it from an accessory apartment, which by definition is part of the main dwelling. The "but" is significant because it essentially says that you can, an accessory cottage is not part of the main dwelling. And I love Mr. Nichols's question. It's probing question of the night, really. And frankly, what's being offered up is a circuitous argument. You might as well say a separate and subordinate dwelling unit that is located on the same lot as a single-family dwelling, but is contained within itself. Because every single time you propose a cottage under this formulation, it qualifies automatically. That's not the intent here.
Anybody? Questions or for Mr. Eliason? Mr. Townsend, I can tell you.
Just one quick thing. At one point, and I appreciate a number of folks standing in support of the applicant and not feeling the need to express their support in another fashion. Is there anyone here or online who wishes to speak in opposition to the application, recognizing that it's questionable to what degree those comments would be relevant? Is there anyone here? Seeing none. All right, that was just for the record. I didn't expect to see anybody.
We have someone online? Okay.
If there's anyone online that'd like to speak in opposition to this application. If you're joining us by phone, press *3 to raise your hand, or you can use the raise hand icon. I see no hands raised on WebEx at this time.
Okay, so Mr. Townsend, we did, as Mr. Lyson was about to speak, have a lady in the back of the room who had her hand raised and wanted to ask a question, and you're certainly welcome to ask that question. Yes, you may.
Good evening. My name is Edie Makarev. I live at 1970 Highland Avenue, Dover,
Ma'am,
Delaware.
Do you affirm the testimony given this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, so typically I will just tell you that this board doesn't answer questions as was indicated. This is your opportunity to speak. But you've been told that you can ask your question. I can't promise you an answer.
Fair enough. My question is, if the accessory cottage proposal gets enacted, what happens to the current garage on the primary dwelling, which I believe is a multiple car situation?
That honestly is not a question we can answer because, to be honest, I'm not sure there's a what happens if answer. So I'm sorry.
Thank you.
Anybody else? Mr. Saunders, you're out there, you're hearing?
No, I'm good.
Okay. All righty. So that concludes this hearing.
Okay. Seeing no one else, we will close the public hearing for application A-21-46 for Mr. Kirby.
Okay, so prior to calling to order the business meeting, does anybody need a break or would you like to move forward? Okay. Okay, we've had a request for a break, so we'll come back at in 10 minutes, so it would be 8:53.
Thank you very much.
Welcome.
Oh, hey, how are you? I'm good. Good to see you. Yeah, it's been a long time. Yeah, you're looking well. How you been? Smelling the roses, aren't you? Well, when do you come? That's it, man. Family's good. Oh, yeah, everybody's good. Kids are all grown. Oh, I know. I miss them so much.
I know, but it's their turn.
It is their turn. But I am going to Pittsburgh tomorrow to visit my oldest and her husband.
Good to see you.
Hey, bud, what's going on, man?
Way to make a living, isn't it?
Yeah, it is. Good to see you, bro. How you been? That's it. Did you see where Mr. Marshall B&B died, 84 years old? His mother is still alive. She's like one of the two, one of three. I heard that. So I don't know. I think they'll catch them.
all and 11 more.
I think we have everybody back.
Miss Denny, I think we have everyone back now.
Okay, thank you.
You're welcome.
Okay. So at this point, we're going to call the business meeting to order. Would you please call the roll?
Yes, ma'am. Miss Hudson?
Here.
Mr. Saunders?
Here.
Thank you. Mr. Nichols? Mr. Jenkins?
Here.
Mr. Carlson?
Here.
Miss Denny?
Here.
Thank you, ma'am. So we have the 6 members present and 1 absent.
Okay, so we certainly have a quorum, and at this point, we've called to order, and our first order of business is approval of the minutes from the November 18th meeting. Need a motion.
I would like to offer a motion to approve the minutes of the November 18th Board of Adjustment meeting, 2021.
Ms. Denny, I was absent from that meeting.
Okay, so we need a second.
Second.
I'd second it.
Okay,
second Mr.
thank
Saunders.
you. We have a motion and a second. All in favor?
Aye.
Aye. Any nays?
Aye.
And we do have 1 abstention. No, yes. We have 1 abstention. It was not here last month. So having reached, are we all said, I'm like losing it here. Yes, they are here, having received all yays. We are, the business meeting minutes from November 18th, 21 are hereby approved. Next order of business is the approval of the notice of decisions, and they would be A 2140 through 43. So I need a motion and a second for that.
Yes, I'd like to offer a motion to approve the notices of decisions A 21-40, -41, -42, and -43 of the November 18th, 2021 Board of Adjustment.
So we need a second?
Second.
We have a motion and a second. 1 who is abstaining because he was not here. All in favor say aye.
Aye.
Any nays?
Aye.
Any nays? Hearing none, the notice of decisions, A 40 through 43 are hereby approved. So we have no old business, so we're going to move on to new business, and we will hear those, the applications first, and then the appeal second, and we'll just hear the applications in the people who have remained first, please.
So first we have application A-21-44 for Mrs. Toe and Mr. Whitehead. They are asking for a variance from the requirement that a fence may not exceed 4 feet in height in the front setback to install a 6-foot fence in that front setback.
Okay, so do we have any discussion, any thoughts?
Yes, I think we do.
Yeah, I was thinking this is a unique one, like we've seen before. It is a corner lot. This lot does have 2 front yards per se. So I believe that there is the practical difficulty of having to put in a fence that has 2 front lots that have 2 front 25 front setbacks.
Is there any concern at all about the issue that there is another lot, I believe, on Lulu, but it was permitted in error? Any discussion there? Or just the overall composition of the development generally doesn't have 6-foot fences?
Well, does anybody else have a comment?
Yeah, well, yeah, the neighbors have expressed concern on both sides, on the Lulu side and on the Mariana side, and it sounds like they have valid points. At the least, I would say that you could possibly have a modified approval for the fence if it was 10 foot back, and possibly even in the front. Safety is, once you put it up, it's up. Safety, there are children, there are sidewalks for a reason, and kids are not watching out for cars coming out of driveways. So a couple of the neighbors have expressed that the 10-foot setbacks would definitely help. There are also other means. If you had a 4-foot fence, they make dog fences that go underground. We have a collar on the dog that could also be utilized. They still have their solid fence, maybe 4 foot, and it's fairly inexpensive to put in this dog fence within the perimeter to keep the dog from jumping over the fence. That's just another option, possibly.
But we do have to remember it is 100 feet away from that stop sign and 16 feet in from the road. So 16 feet's 2 car lengths already. So they have a sidewalk there from the road over. The applicant said it would be 16 feet where they're putting the fence. So if you put another 10, you're putting it 26 feet from the road. So at 16 feet, that's 2 car lengths. And then the fence doesn't start until it's 100 feet away from that stop sign.
At 26 feet, would that be on Marianne or was that Lulu?
Marianne, and then Lulu is 100 feet.
Yeah, we're at this point, we're discussing more appropriately the Mariana because there is already 100 feet with the Lulu. And I just want to, as part of the discussion, make a comment that there are within the county jurisdiction, there are many, many developments, and I would say, I'm not going to say all, but I'm going to say most of them have what we call double fronted lots, because every time there's a corner, a house built on a corner, there's a double fronted lot. And so while I respect what you said, to me, that's not an exceptional practical difficulty generally, because they are everywhere. I mean, well, not everywhere. That's an exaggeration. So I just want to mention that.
If I could speak to that as well. The question is not whether they can have a fence, it's whether they can have a fence that exceeds 4 feet in height. So they're certainly entitled to have a fence at the appropriate height that runs directly on that property line without a variance.
I have a question of counsel. What weight, if any, does the board have to give to the deed restrictions that are built into the community of the property? Any? None?
So this is a question that comes up often, and the county does not view itself as the enforcer of restrictions, which are private contracts or covenants between residents of a community and other residents of the community and any governing entity for the association of members. So there are many examples of restrictions that can't be enforced due to their having been waived over the years, and it's not appropriate for the county to try and determine which of the restrictions should be enforced versus others. We enforce our ordinances, and that's where it stops.
Any discussion? Anybody else?
And there was an earlier question about what, I think essentially what weight to give the fact that there may have been a building permit issued. I don't know that we have any reason to doubt the testimony, but I don't think we have, I'm not sure that we've got competent testimony. We have hearsay that was offered that a building permit was handed out, but I don't think the planning office has indicated that there was a wrongly executed building permit with respect to a fence in that community.
Question for staff. Can you clarify if that was actually true or is it just hearsay?
Even if it did, what weight does it hold?
It would set the precedent, like with the 6 foot, like the exceptional practical difficulty of being a corner lot, of having 2 fronts.
Does an accidental issuance of a building permit set a precedence for the entire community?
It would not tie your hands. So the building officials, there's a body of law out there that says, of course, people make mistakes, and that applies to building officials as well. So when building officials make mistakes, that does not mean the law has been changed as a result of the building official having made an error. So that would not tie the hands of either that building official or subsequent building officials or this body from enforcing the code.
Any other questions or discussion? So, were you indicating you wanted to speak, Mr. Nichols? Okay. My daughter lives in a county development where the residents are allowed like split rail type fencing. There, and that's part of their deed restrictions. So certainly, those are civil matters, and it doesn't bear on us. But in order to comply with her deed restrictions, she has the split rail fence, but she has the invisible fence around the top and a collar on the dog. And after, I would say, maybe 4 hits, because initially I was like, oh my gosh, that's cruel. But after 4 times, Annie does not even go near. So I just want to throw that out there. That said, anybody else?
I think if I remember correctly, or if my notes are correct, the representative for the HOA was okay with the 10-foot off property line, if my notes are correct.
I believe that was part of the testimony as well. I'm sorry, at this point, I can't. You had your turn, and I apologize, but that's the way it is.
But if I remember from the applicant's testimony, they did say that their dog, one of the dogs, doesn't do well when they see other animals. So if it's a fence with rail, and the lady who also testified said that she walks by every single day, what if the dog jumps their 4-foot fence, or the dog starts interacting with her dog, and they're bringing us a problem, a foreseeable problem that they see that they could fix? And like Fred said, it's not saying that they can't put the fence there, it's just the height. So they could put a 4-foot fence there up on the property line. So in the 4-foot, we're talking about the 2-foot for the variance. That's what.
Anybody else? More comments or a motion? One of the members was suggesting maybe that it be from the visibility to the neighboring driveway aspect, that perhaps we could consider, maybe meeting halfway on the 25-foot on the side setback. But at any rate, and that's up to me. I never make motions. But
a question for staff: if they did put their 4-foot fence on the property line like they want, is it still considered a fence if they do the white lattice on top You know how some fences, is that still part of the fence or that would be acceptable?
Yeah, the total fence height would only be allowed to be 4 feet, including the lattice.
Okay, so we're looking for a motion or either more discussion or a motion. You just can't sit. Okay. Okay, so Mr. Crossan's working on a motion.
Well, I'll make a motion that we approve A-21-44 based off staff recommendations. The failure to remove the restriction would put an exceptional practical difficulty on the homeowners to improve their property reasonably. And this is an exceptional practical difficulty, in my opinion, because it has 2 front lots and has to adhere to 2 25-foot setbacks.
Okay, we need a second in order so that we can at least discuss it or vote on it.
I'll second that.
So we have a motion and a second. Does anybody want to make any comments or have discussion?
Yes, is this for a modified or just a?
I believe that the motion was as it is asked, as it is requested.
Okay, staff recommendations.
Yes. Now, I'm going to say that based on testimony of a neighbor, actually the immediate neighbor, with regard to visibility issues as she egresses from her driveway, I believe that there's a safety issue with the 25 feet on Mariana. And so I feel that it would be better if we were to modify that part of the request and make the fence split the 25, and I'll even say I'll go with 10. My preference would be 12, but narrow that 25-foot side setback. I'm putting that out there.
Madam Chair, I might be out of place, but I think we have a motion and a second on the table. So
we have a motion and a second, but we're allowed to have a little discussion before we vote. And then we can vote, and then it'll either pass or it'll fail, and we can look at another avenue. But that's my discussion.
I would agree with the 10-foot. The HOA and 2 of the neighbors both expressed that the 10-foot would work for them. I'm still a little concerned about the front being right coming down Lulu and being able to the same thing. But I'm not sure if that's
the front setback to Lulu is behind the dwelling, and so that's not before us, nor would it be, because it's legal. Or if it's not, somebody correct me, but okay. So at any rate, so we've had some discussion, and at this point, so we have a motion before us. We've had some discussion, and we're looking at this point to call the roll on what we have existing.
I had another comment.
Go ahead.
It's in regards to, I believe it was Jean Bentley, who was right behind the rear property line. And I think she had mentioned numerous times about backing out. And it clearly looked like there were an option there to pull out. The way the driveway was paved, it looked like you could back in that, looked like an accessory parking area and then pull out. Like reverse is not the only option.
I would agree that seemed, I asked the question of the immediate neighbor, and it did, the answer was that while you can maneuver it, it was more difficult to make that turn in order to egress forward. Okay, so now let's call the roll on what we have before us.
Mr. Saunders?
Yes, I vote yes to approve a modified approval.
It's not modified.
Mr. Saunders?
Oh, not modified. Okay.
Okay. So the motion is to approve the variance request as it was submitted, which is for 6-foot fence in the setback along Mariana Drive.
Okay. Okay, I vote to approve based on the staff's recommendations for the approval of the variance.
So is that a vote in favor of the motion?
Yes, a vote in favor of, based on testimony and the staff recommendations.
Thank you. Mr. Nichols?
I vote against the motion. I do so because I visited the area. I don't believe that this 6-foot fence comports to the character of the immediate vicinity. The applicant does have other fencing alternatives that could be utilized, so I don't feel that denying the application places any undue restrictions on them. And I am concerned about how a 6-foot fence might affect the property values of those people that live adjacent to the property. So I vote against the motion.
Thank you. Mr. Jenkins?
I vote yes in support of application A21-44 based upon the original motion viewing this lot as having exceptional practical difficulty in terms of 2 property fronts.
Thank you. Mr. Crossan?
I vote to deny the application A2144 as recommended. I believe that there are other options. HOA and neighbors both mentioned that just by setting back 10 feet the fence, that would make a large difference in safety. And also I agree with the character of the neighborhood, a 6-foot solid white fence of that size, especially when there are other alternatives, solid, shorter, that can be utilized. So I vote to deny it.
Thank you. Ms. Hudson?
For A-21-44, I vote to approve based off my motion.
Thank you. Ms. Denny?
For application A2144, I'm going to vote to deny based on testimony that was given to us this evening. I realize that there is, in their opinion and my opinion, a safety concern in that invisibility as you are egressing from the 2 properties at least behind the house. And where I would be open to a modification if that were just adjusted in 10 feet, I would be okay with it. But I definitely, as a matter of safety, do not think that having that that narrow setback, I mean, that is a good idea.
So that leaves a vote of 3 in favor of the motion, 3 against the motion, and 1 absent.
Okay, so we have a tie. So at this point, it fails, and we can entertain another motion and vote. So at this point, the motion on the floor is denied as it was a tie. So I would be looking to entertain another motion.
Mr. Townsend, would it be a modified approval if the recommendation was for a 4-foot solid fence? Would that be?
They don't need a variance for a 4-foot solid fence. The fact that the fence is solid versus split rail or something else is irrelevant.
So we do need a motion, I think. And to me, based on the testimony and the safety issue, because keeping in mind that the two women who spoke this evening, when they back out of their driveways, or I suppose even if they, either way, when they egress their driveways, not only are they going into a vehicle right-of-way, they're crossing a pedestrian sidewalk in a community where people walk, children play. So just putting that out there.
We can make a motion to deny.
So it failed. So it failed because we were a tie. So it's off the table. So now I'm looking for another motion. And again, whether that's modified, the height of the fence, as was said, is if it was 4 feet, and the testimony given was that they need it to be higher than 4 feet.
So your duty here is not necessarily to pass a motion, but it is generally the case that when you've got a variance that fails by virtue of a 3-3 vote, that you at least spend some time, as you are doing and have done, to determine whether there is an alternate motion that can be passed. You do not. At some point, the gavel can come down and say we're moving on to the next agenda item. You do not need to pass. It's not my opinion. I think I probably said the opposite years ago, but it's not my opinion that you have to pass a motion to deny, because if the motion to grant the variance was 3-3, the motion to deny the variance might also be 3-3, and that'd be pointless. So I think you could declare the variance denied as a result of not getting a majority of the members to support it. And at some point, you'll need to determine whether there's any benefit to continuing to consider an alternate motion.
Okay, with that advice, then I will, at this point, it was a tie, and so we will consider that motion, because of the tie, was denied, and so I'm looking for another motion, hopefully. And second. So I just want to point out that two things. Number one, the planners did recommend approval. No, that's number one. Number two, I would hate for for these applicants who stayed here and who went through and paid their money to leave here with no decision. So I just want to mention that, and so I would hope that somebody will make some movement on this.
There is the option to table it until next month when we have the other member present.
Who wouldn't have heard all the testimony, although I guess they could read the minutes, but.
They could prepare. There is a recording of this meeting. Is that not the case?
That is true.
All right, well then, if somebody wants to make a motion to table, I'm happy to hear that as well. Motion a second to table.
I'll make a motion to table application A21-44 based upon the fact that we couldn't come to a conclusion on our decision.
Second.
So we have a motion and a second to table application A21-44. All in favor?
Aye.
Aye.
Any nays? I'm going to throw a nay in there. I think this could be settled this evening, but at any rate. So,
what makes you say 10 feet would suffice? Why 10 feet? Why are we all upset on 10 foot?
Well, I'm putting 10 feet out because that was suggested by the neighbors, the two neighbors,
And the
that
HOA.
if they had, and the homeowners association, and because their belief is that extra 10 feet on that one sideline would give them the necessary visibility for safety. And in the testimony, the first lady to speak, whose name I have written here somewhere, said, the very first neighboring property, said that 10 feet, as she's leaving her driveway, would give her more time to react. And I think she actually said if there was a child so it would just give her more, that 10 feet of visibility when she pulled out gives her just a little bit more reaction time as a safety issue.
So I will point out, though, that at this point we have tabled the motion.
Well, we have a motion, but not a second to table, right? Is that? Oh, okay, we have a motion and second, and all in favor, right?
I think you called the vote, and you voted no, so it was 5-1.
Yeah, I'm getting tired. Okay, so 5-1. So at this point, we will table it until next month's meeting. Moving right along.
Next, we have application A-21-45 for Mr. Munyon. He is seeking a variance from the required 150-foot road frontage to perform a minor subdivision.
Any thoughts or comments or a motion?
Well, due to the irregular lot size and the fact that there is a dwelling.
Mr. Carlson, can you please hit your mic?
Due to the fact there's a unusual lot size and there is a historic building on the property which is in play, and the road, which is a very strange, hard curve there, it appears that there is an exceptional practical difficulty and that it just isn't enough frontage to make these frontages to comply with the county's code. So he is asking for reductions of approximately 50 feet from each of those two. I don't see any other way of getting around it, especially to the lot that he wants to build on. There's just not enough road frontage to make it happen.
I would take a question. Is this self-imposed since there is 20 acres here?
Well, there's 20 acres, but the property line doesn't border on the roads, and the county's asking for the 150 feet of road frontage, but they're just simply, the lot to the right that he wants to build on, the property line goes off and doesn't go along the road. It's owned by another person.
So I can try and add something to that. So the fact that an argument could be made that the applicant is facing an exceptional practical difficulty that is self-imposed, it is not to be disregarded, but it also does not disqualify someone from seeking a variance. So the analysis, I think, is that if the applicant's difficulty is self-imposed, then he or she has something less than an exceptional practical difficulty. But if the effort is to make normal improvements to your property, and if you strictly applied that argument, and the courts have said that you're not disqualified from requesting a variance by virtue of the contention that your difficulty is self-imposed, because you can purchase property with the intent of seeking a variance in order to do what you view as normal in the way of improvements on the property. So if the request is normal and not out of character, even though in the absence of the request there would be no difficulty, the application can still have merit.
I'm looking for a motion.
Okay, Crossan, I'm going to make a motion to approve A2145 based on the fact that in order for the applicant to improve upon his property, there really is no other way that I see that he could achieve that without reducing the size of the frontage to access that lot. And therefore, the lot that's next to it, there would also not be sufficient frontage. And so therefore, the two basically 100-foot frontages instead of 150s would be needed to improve the property. I don't think it's going to make any effect on any additional, any adjacent neighbors. He obviously owns the lots on both sides at this point, or at least on one side. And as far as being out of character for the area, the lots are all basically the same except for his, which is actually larger. So my motion is to approve.
So you have a motion to approve. I'm looking for a second.
I'll second his motion.
Okay, so when you're ready, will you please call the roll?
Yes, ma'am. Mr. Nichols?
I vote in favor of the motion. Failure to remove the restrictions would create unnecessary hardship or exceptional practical difficulties for the owner of the property.
Thank you. Mr. Saunders?
I vote to approve as well based upon the testimony and the exceptional practical difficulty of how the land is set out.
Thank you. Ms. Hudson?
For A-21-45, I vote to approve based off the character of the area does not change. I do believe it's a practical difficulty with exceptional practical difficulty with the curve in the road. And I believe it does stay in the character of the surrounding area.
Thank you. Mr. Jenkins?
I vote yes in support of application A21-45. When you consider the complexity of the curve, that distance compared to the other two lots, I don't see that as being out of character at all. And it does seem to be an exceptional practical difficulty if you treat the curve.
Thank you. Mr. Carlson?
I'll vote yes to approve based on my motion.
Thank you. Ms. Denny?
I'm going to vote yes to approve. I do see a couple exceptional practical difficulties. Certainly, the curve in the road is a major one, and the desire to respectfully preserve the historic house property. I just think this really needs to be approved, and not to set a precedence, because this really is a unique situation. So yes.
Thank you. That's 6 in favor of the motion.
Having received unanimous positive votes, application A2145 is hereby approved.
Thank you. Next, we have application A-21-46 for the appeal of the interpretation of an accessory cottage.
Ms. Denny, I'll recuse myself from vote.
Okay, so Mr. Crossan recusing.
I wanted to ask Mr. Townsend, do you have any input that you can offer us on how we should treat this appeal?
So, do you have any specific questions for me?
Do we have to stay right in line with the definition as it's articulated before us and just affirm or deny that application based on the definition that we feel was presented to us, or which lane do we go?
So we have mentioned a couple of times that it is not your job to legislate what you think would be the appropriate regulation or rule, or in this case, definition for an accessory structure or accessory cottage. So instead, your responsibility, and it is a weighty one, is to take into consideration the arguments that you heard here and come to a conclusion as to what is the appropriate definition of an accessory cottage.
My concern, if I might, is counsel's for the applicant's argument that a outbuilding becomes an outbuilding when it's constructed. And counsel for the county is, in my opinion, correct in saying that if that were true, then any number of outbuildings could be constructed on a parcel and thereby identified as an accessory cottage. That leaves open the door for the type of development that certainly would not be in character with any community. And I also agree with counsel for the board that it's not our responsibility to try to legislate, that we have to interpret the code as written, and that while Mr. Pardee made a lawyerly attempt to redefine an outbuilding as a building yet to be constructed in order to fit it within the ordinance, I find that his argument fails. And further, I'd like to make a motion to deny application A21-46.
Okay, so, well, not necessarily out of order, but I'm going to rephrase it, that it's that you're making a motion to affirm the determination of the definition as made by the planning office. Is that right?
That is accurate.
Now, before you ask for a second, it is always important that the board members give ample justification for their position. And when we have an appeal, it's even more important because the likelihood that your decision will be reviewed is increased. So
let me restate my unclear motion. That application A2146 does not meet the definition of an accessory structure as defined by staff. And staff says does not meet the requirement for an accessory cottage to be contained in or within a subordinate accessory structure. And that's my basis for the motion to deny.
So if I could continue just briefly, before you get your second, I think the motion as stated is a motion to affirm the reading right of the Planning Commission.
That is correct.
And I would just like to ask the members to deliberate thoroughly over this as they justify their or before they vote and justify their positions. Thank you.
So at this point, we're looking for some discussion. Okay. Well, first a second, I guess, and then discussion. So if somebody wants to second it so we can put it on the floor and have discussion, that would be helpful.
I second.
Okay, thank you, Mr. Saunders. So we have a motion and a second to deny.
To affirm.
To affirm, I'm sorry. Good Lord.
Affirming the county's
Affirming the county's decision, or interpretation. So, that said, now we can have discussion. And I certainly, and rarely do I speak first, and maybe I should let everybody else speak first. But either way, I've been doing this for a long time, and I also managed a town, and tried to make the town coincide a lot in codification with what was going here, so we didn't have all this people coming to want to leave or annex and all of that. So I believe that the definition of accessory cottage, a separate and subordinate dwelling unit that is located on the same lot as a single-family home, in a detached garage or outbuilding, is appropriate, and frankly, I take exception to the thought that so now you build an outbuilding just so that you can put up an accessory cottage. I think that that's inappropriate, and those who have been here for many years with me realize that I, in the 20-some years I've been doing this, I regard our code, you've heard me say it many times to applicants, this isn't a book of suggestions. This is our code, and it has served this county well over the years. There have been some changes made, and if going forward a change somehow would need to be made, I'm not willing to say one way or the other, but at this point, as it is written, my interpretation is that I agree with the interpretation of the planner on that day at that time.
I would agree.
So, any more discussion? And then, so I guess we're looking to call the roll.
So you can call the roll, but the instruction is to give ample justification support for your vote on the record.
So at this point, does anybody want to vote and be and explain very well the reason for their voting? Because we do need to take a vote.
I would like to vote.
We should be calling the roll.
Okay.
Okay.
Okay. Ms. Hudson?
For A-21-46, I vote to affirm the county's ruling. I believe the county's definition is clear. An accessory cottage is within a building that is currently on the property. I believe going to build a building to put an accessory cottage defeats the purpose of the definition that was given by the county.
Thank you. Mr. Saunders?
I vote to affirm A-21-46, based after testimony from both the lawyers and Mr. Kirby and the staff, and I believe that the planners had interpreted the code correctly, with the definition of accessory cottage correctly. Like I say, it needs to be an outbuilding or a garage built after it was already there.
Thank you. Mr. Saunders? Or, I'm sorry, Mr. Jenkins?
I vote no for the affirmation of application A21-46. My vote is in reverse of that based on the definition that I have before me this evening.
Can you give some support to that?
Well, the language that says contained in a detached garage or other outbuilding is enough to cause my decision to be a reversal.
Thank you. So it goes back to Mr. Nichols.
I vote to affirm the staff ruling on A21-46, interpretation of an accessory cottage, a separate and subordinate dwelling unit that is located on the same lot as a single-family unit, but is contained in a detached garage or other outbuilding. I interpret that to mean building already in existence.
And Ms. Stenny.
I'm going to vote to affirm. My interpretation certainly agrees with the planner here. A separate and subordinate dwelling unit that is located on the same lot as a single-family dwelling and is contained in a detached garage or other outbuilding. It is not in a detached garage. They are building a garage to attach it to, and to me, it's purposely trying to defeat our code. So I vote to affirm.
Thank you. So that is 4 in favor to affirm, 1 nay, 1 recusing himself, and 1 absent.
So at this point, we have 3 votes to affirm. 4. So having reached the appropriate amount of affirming votes, the appeal is affirmed and in favor of the planner's interpretation.
Appeal is denied. The motion to affirm is passed.
So let me restate that. Having received the majority of votes to affirm this evening, the application, say it again, Fred.
The application is denied.
The application is denied. The appeal, the application of appeal is denied based on the votes this evening. So, and let me just give a number to that. It's application A, gosh, my papers are all messed up here. Application A2146, which is an appeal, is hereby affirmed in favor of the planner.
Okay.
All right.
And if I could ask the members to, due to the late hour and other considerations, I would ask that we not go into executive session, and we save that for another meeting.
I certainly agree with that. This has been just a lot of information, and we've had meetings that will go a lot longer, but it's, okay, so that being said, I need a motion to adjourn.
Motion to close. Adjourn.
Second.
Second.
Motion and second to adjourn. All in favor?
Aye.
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 Right.